Good morning. It's a pleasure to be here today to talk to you about the AMPS regime under the Environmental Violations Administrative and Monetary Penalties Act, which we affectionately refer to as EVAMPA, and that's how I will talk about it today as well. Before diving right in, I thought I'd just provide you briefly with a map of where I come from within the department to help situate the kind of work that our team does. So you'll see I'm with the Legislative Governance Division, and that is under the Environmental Protection Branch in Environment and Climate Change Canada. But as the department's focal point for law reform, our work and the responsibilities, and the responsibilities we have, there you go, sorry about that. And the responsibilities that our division is responsible for will work across most of the branches of the department. And our work leading the implementation of the Environmental Enforcement Act and EVAMPA is a good example of this horizontal role that we play. I guess for the past 10 years, we've worked with the Canadian Wildlife Service and the enforcement branch on implementing this legislation. And now that EVAMPA is in force, the enforcement branch is actually leading the operational implementation of it, but having worked on it for 10 years, I'm still in a pretty good position to walk you through our legislation and the regime. So moving on now to the business at hand, I'm going to provide you with a bit of background on EVAMPA and then remind you of a few common aspects of AMPS that are generally shared by many regimes, and then we'll look specifically at the AMPS regime under EVAMPA. AMPS came about for Environment and Climate Change Canada during the development of the Environmental Enforcement Act. And this act strengthened the enforcement regimes of 9 acts under the responsibility of the Minister of Environment and Climate Change. And I guess actually Aaron and Alex spoke briefly to the fine regimes and some of the sentencing provisions of some of these acts that were amended by the Environmental Enforcement Act. So that's the type of amendments that came into force under that act. In addition, this act also created EVAMPA, a new act. The purpose of EVAMPA is to establish as an alternative to the existing penal system and as a supplement to existing enforcement measures, a fair and efficient administrative monetary penalty system. It has been in force since 2010, and it provides authority to establish AMP regimes under 12 acts under our minister's mandate. And they include 7 that are administered by Environment and Climate Change Canada, 4 that are administered by Parks Canada. There are certain provisions of the Canadian Environmental Assessment Act 2012, which I would note is proposed to be with amendments in Bill C-69. This part would be changed to add provisions of the Impact Assessment Act. It is also proposed to add the Greenhouse Gas Pollution Pricing Act to EVAMPA and in the draft legislation that was released earlier this year. EVAMPA does not apply to the Species at Risk Act or the Fisheries Act. So before diving further into EVAMPA, I wanted to go over quickly just what AMPs are, just to refresh your memory. They provide a financial disincentive to wrongdoing, not punishment. They're typically issued by administrative officials and usually reviewable by an administrative body with no recourse to courts. While AMPs are new to us at Environment and Climate Change Canada, as Alistair mentioned, they've been around for many years in both areas of provincial and federal jurisdiction, and it was really in the 90s where we saw their popularity begin to increase into many more fields, and it continues to increase today, the use of them. Some of the reasons for their popularity include that they can avoid the time-consuming and moral stigma that accompany a criminal conviction, and they can be tailored to address compliance issues associated with regulated fields that require a high degree of expertise or where traditional sanctions, such as fines or imprisonment, may not be achieving full compliance. I'll just note that AMPs do not create any new legal obligations, and they do not create any prohibitions or any limitations on conduct. So now I'll talk to you about the AMPS regime and how it works under EVAMPA. EVAMPA is an enabling act. It sets out the parameters of the AMPS regime it authorizes, and some of these parameters include, for EVAMPA, that it is purely administrative. There's no possibility of imprisonment. You cannot AMP and prosecute for the same violation, and due diligence is not available as a defense under this regime. There are maximum penalties for individuals of $5,000 and other persons, ships, and vessels. The maximum penalty is $25,000. For corporate directors and officers who have directed or authorized or participated in a violation, they are liable to an AMP. And alleged violators may request a review of the facts of a violation, the penalty amount, or both to the Chief Review Officer. And the Chief Review Officer is an independent arm's-length adjudicator that is appointed under the Canadian Environmental Protection Act, and there are also 2 review officers appointed under this act. These are adjudicators that already exist and review compliance orders that are issued under environmental legislation for Environment and Climate Change Canada. All revenue from AMPS is credited to the Environmental Damages Fund, and this is the fund that you heard Aaron and Alex mention yesterday, where it's traditionally been court-imposed fines that have been directed there, but now AMPS will be added to this pot, and it will continue to grow as well. As of June 2017, the Environmental Violations Administrative Monetary Penalty Regulations, and I'm going to shorten that to the AMPS regulations, are in force. And these AMP regulations only designate violations under 6 of the 12 possible acts under EVAMPA. All of these 6 acts are administered by Environment and Climate Change Canada, and I've listed the 3 wildlife acts that are part of this regime on the slide. So you have the Canada Wildlife Act and the Wildlife Area Regulations under that act, Migratory Birds Convention Act and its regulations, and WPREDA and its regulation, the Wild Animal and Plant Trade Regulation. It is possible that in the future there could be other regulations under EVAMPA that would operationalize an AMPS regime for any of the other acts that it applies to, but for right now, this is the only one that exists. The general approach to designation for the AMPS regulations was that virtually all violations that could be proceeded with as an offense in the penal system were designated as being possible to be enforced by means of an AMP. There are 3 schedules at the back of the regulations that will list all of the provisions under these 6 acts and associated regulations. And there is an exception to the types of provisions designated. No mens rea offenses were designated, or so any provisions with that mention the words such as knowingly or willfully. Under the AMPS regulations, calculating the baseline penalty is the first piece of the method for determining the penalty. So each designated violation is classified as either type A, B, or C. So when you go to those 3 schedules I mentioned, you can go look up the provision, the designated violation, and there will be a corresponding letter associated with it. So the letters, what they mean, a type A is administrative, usually less serious. An example may be failure to possess a permit while you're hunting. Type B are those violations that are more serious, and there's a risk of harm or obstruction of authority associated with the violation. And hunting or fishing in a wildlife area is an example that we pulled, because you could be hunting and fishing and have not caught anything, or if you have actually caught something or caused harm, then there's a possibility of risk to the environment. For type C offenses, there are most serious offenses, and they are inherently harmful. For instance, depositing a deleterious substance that is harmful to migratory birds in an area frequented by migratory birds. The baseline penalty amounts for a type A, B, or C violation will also vary depending on whether the violator is an individual or another person, such as a corporation or a ship or a vessel. The second piece to determining the penalty is the application of the aggravating factors, which, if present, result in an increased penalty. The AMPS regulations set out only 3 aggravating factors that may be applied. So there is history of noncompliance, and it is applied if in the previous 5 years from when the violation occurred, specific enforcement actions involving a finding of guilt or liability exist for the same regulatory regime. And this supports the non-punitive and promotion of compliance goal of the AMPS regime. And an example might be that if there is if considering a violation under the Migratory Birds Act and considering an AMP for that, if 2 years prior the same person was prosecuted or convicted for an offense under the Migratory Birds Regulation, that's within the same regulatory regime, and that would count as history of noncompliance. The next aggravating factor is environmental harm. This is not defined in the regulations, but there is a policy framework document, which I'll discuss in a bit, that provides some guidance on what environmental harm might constitute. As an example, the policy framework document mentions that in the event of an observation or measurement of the killing, harming, harassing, or capturing or taking of a wildlife species, this would be evidence of environmental harm. And the final aggravating factor is economic gain. And this economic gain, there's actually may differ depending on whether the violator is only avoiding the cost of a permit or authorization, or whether they have actually experienced some other economic gain from committing the violation. So the next slide helps visualize what I've just talked about. And so if we just walk through this is actually representative of what you'll find at the final schedule of the AMPS regulations, Schedule 4. So if you start on the column with identity of violator, you'll see you have either an individual or other person. And then you look across and you can see the baseline penalty. So depending on in Schedules 1, 2, or 3, what provision is designated at. If it's an individual, you have the baseline penalties ranging from 200 to 1,000, whether it's type A, B, or C. And you can see the baseline penalties for ships, vessels, or other persons as well. You'll notice under the aggravating factors that if these are present, then they must be applied. There's no discretion. And history of noncompliance under this column, these are the steepest fine or steepest additional amounts that may be added to the penalty. And that goes to promote the purpose of this, the use of AMPS to promote compliance and deter future noncompliance. For environmental harm, it is a lower amount that would be applied, but if there is significant environmental harm, then it's possible AMPS will not be the appropriate tool for that violation. You'll see that type C violations, there's no additional amount of environmental harm that would be applied, and that's because, as I mentioned, it's inherent in the type of violation. It has occurred and is already factored into the baseline penalty. So then for economic gain, you'll see there are 2 amounts for permits, and that's the avoidance of a permit, and the other category is if there is economic gain that results in profit or something similar to that. And only one of these amounts will apply, so you cannot apply both. And then if we just work our way across, you'll see the maximum penalty, as we discussed, is $5,000 for individuals and $25,000 for a corporation. So in order to arrive at this maximum penalty for individuals, you need a type C offense with the presence of history of noncompliance and economic gain other than the avoidance of a cost of permit. And it's the same, it would be type C for other persons with the same aggravating factors present in order to reach the maximum. I just point out there are no mitigation measures taken into account. And also of note, a violation committed or continued on more than one day constitutes a separate offense each day and a separate violation. And the method used to determine the amount of an AMP is intended to be simple and straightforward, a calculation that's based on factors that can easily be measured, determined, or calculated, and this is to allow the AMPS regime to be used in a consistent, fair, and efficient manner, going back to the purpose of the Act that we talked about at the beginning. And moving on to the operational considerations for this regime, these I often find are which generate the most interest. But I would just mention that now Enforcement Branch is leading on this, and so I will do my best to kind of cover some of these issues that may be of interest. There's also an AMPS policy framework document that I mentioned earlier, and it's available on Environment and Climate Change's website, and it provides further information on the operational aspects of the AMPS regime. But a few key points to note that under this regime, it's Environment and Climate Change Canada's enforcement and wildlife officers that will be designated to issue a notice of violation where they have reasonable grounds to believe that a violation has been committed. And this is different than many regimes where it may be a program administrator or a different administrative official who is issuing the notice of violation. And I will mention that a notice of violation, a new term I've just introduced, is actually the legal document that sets out the key details surrounding a violation and the AMP, or the penalty amount. And a notice of violation under our regime can be issued on the spot, or it can, like a ticket, or it could be issued for up to 2 years after which the subject matter of the violation arose. The alleged violator, as I mentioned, has 30 days to request a review to the Chief Review Officer. I would note that the Chief Review Officer and the 2 other review officers operate under the name Environment Protection Review Canada, and they have recently released draft rules of procedure for how an AMPS review would be conducted eventually. And then for wildlife enforcement officers, AMPS will be one more tool in the enforcement toolbox. AMPS are not going to replace other enforcement measures, so warning letters, compliance orders, prosecutions will still be used, but the AMPS are intended to provide an alternative to the range of options currently available. Wildlife enforcement officers will continue to use their discretion to choose the best enforcement measure to bring violators back into compliance, and they operate when making their decisions in accordance with the principles set out within Environment and Climate Change Canada's compliance and enforcement policies, which are available on the website as well. So that concludes my presentation, but I have provided a few more links too, in case you are interested in more information. Thank you.
Given the time that we have with this panel, it would be appropriate to go to questions right now, and then perhaps we can pick up further questions at the end of both presentations. So are there questions for Megan? Now, do we have microphones? Yes. Oh, sorry, Nancy. Thank you.
Thanks, Megan. My question is, you had mentioned that the maximum penalty under the regime applies to each day of a violation. Does that also apply to each animal or each plant?
Yes, under the AMPS regime, it depends how the parent legislation would deal with that, consider it an offense. But as you mentioned yesterday, with the migratory birds and the Canada Wildlife Act, you can proceed with, if it's prosecuted as an offense, you can charge for each species, and that operates, and Repreta, sorry, I should mention, and that's the same for under the AMPS regulations as well.
Yes, thank you.
Yes, good morning. Just a question about that. Every day is a separate offense and every animal is a separate offense. When your colleague spoke yesterday, I did ask a question about something else and I didn't get to this one, but I've always been curious about how it is that the decision is made whether or not to actually impose a penalty for every single day or to actually bring evidence to the court that would prove a separate offense for every day. And I must tell you that I have represented parties that have been charged with environmental offenses, that went on for a while because they involved a spill. And so the question that I kept asking the Crown in that particular situation was, are we really preparing a defense for 20 or 30 or I can't remember the number of days at the moment, but separate offenses, or are you going to handle all of this as a single trial and a single matter? And so I'm curious because I see your colleagues from yesterday are here as well, but I just want to know how it is that the Crown decides when to deal with these things as a separate individual offense and whether that has procedural implications in terms of the way that a matter is brought forward before the courts.
Well, I can leave. I guess unfortunately for me, I won't attempt to answer how they bring forward continuing offenses before the courts. And if Aaron and Alex are able to do that, I can. But I can speak to it a bit in the context of AMPS. I guess going back to the purpose of the AMPS regime, one of the things that is always kept in mind is that it's not for punishment and it is to bring people back into compliance. So depending on the amount of species that would be considered or the amount of days of a continuing offense, we do recognize that it has potential to amount to significant fines. And in those situations, at this point, you'll find in our AMPS policy framework document that those are situations that will be subject to oversight. So we won't be issuing AMPS on the spot for continuing offenses. It will be a decision that is taken back to senior management, and the enforcement branch will apply their policies to see if in that situation amping or issuing notice of violations for each day is what the best approach to bringing that particular violator back into compliance, or if it would be overly punitive. So all of those considerations would be taken into account at that time. In the context of prosecutions, I would leave that to maybe Alex and Aaron to speak to.
Alex or Aaron, any comment?
Should I start this one? This is a little bit of a challenging question because part of the answer is actually relatively similar to what Megan has provided. I mean, part of how we frame our charges is an aspect of Crown discretion. Whether or not that means that you're preparing a defense for individual offenses, well, there's a deeming provision in a lot of the legislation that does deem a continuing offense to be a different offense on each day that it's committed. So that's your answer. Now, if it's your prerogative as defense counsel, if you think that the Crown hasn't made out one or more particular days beyond a reasonable doubt, well, then there's the answer to your defense. Alternatively, if you think that your client has different due diligence responses to different temporal periods of the offense, well, that's also something for you to figure out. But yeah, the short answer to the question is that we do have some discretion as to how we decide to frame the offenses. I don't know if Aaron has anything else to add.
And specifically with respect to the penalty, I mean, if you had 10 birds, we would let the court know what the maximum was, that it would be, wherever you were, your maximum was 4 million, it would be 4 million per bird. That doesn't mean we're seeking 4 million per bird, but we're telling the court that that is the maximum, and so it's a sign from Parliament that these sorts of offences can have and perhaps should have, in some instances, very high consequences. So that's how when I'm
doing a sentencing, I frame it for the court.
Okay, thank you. Further question?
On the civil side, for Alberta, what you've described, for example, for a spill, practically speaking, they would probably treat that as one offense because it happened on one particular day. We've seen, and again, this is on the civil side, where, for example, there's an ongoing release and the release occurs over maybe the period of 3 days. It would not be unlikely to see an administrative penalty coming for 3 different offenses because the company's been unable to shut down the release for that 3-day period. In the case, one of the cases I'm going to talk about, Alberta Reclaim, which is the importation of beverage containers from the Yukon. There were 14 different specific importations that happened over a period of time. So there were 14 offenses committed in that circumstance. So that's how we've practically seen it in the Alberta civil side.
Okay, questions from the group online?
Yes, we have a question and a comment. The question is, where would these actually be held? Like, is there a name for a tribunal or something where AMPs would be?
Oh, if there is a review, yes. So the chief review officer and the review officers, they operate under the name Environment Protection Review Canada. And I guess as a physical place, I think under their draft rules of procedure, I'm not sure that it always has to be in a physical place. There may be options for hearings that occur on like webcasts or WebEx. I'm not sure. I think they are open, but I think their rules of procedure will cover, and they would set up how that will work.
On this same viewer made a comment, so probably just, she says, to add to the conversation, so you might want to comment about it. She says, another option for prosecutions is to charge between dates and then to make submissions on the size of the sentence, which should incorporate the number of days, individuals, etc., to increase the sentence. Do you want to comment?
Well, I guess from the AMP's perspective, as I mentioned, we wouldn't prosecute and AMP for the same violation. So I'm not sure that would those considerations are applicable. Okay.
Yes.
I have a question about the different end, at the other end of this process, and I hope it's not unfair to ask you about that, but the expenditures from the Environmental Damages Fund, what efforts go into matching those expenditures to the nature of the harm done by the violations?
I will attempt to provide an answer because we've been working closely with the folks at Environment and Climate Change Canada that administer the Environmental Damages Fund. They have a coding system for both fines and for AMPs that looks at what legislation they were issued under and then also what area of the country they were issued under. So they do make every effort to put the funds back into projects in those areas. And there is more details also about the process, how to apply for funding, and about how the funding is matched on the Environmental Damages Fund, the website, if you do want more specifics than that. But there is an effort to try to mitigate or put the money back into the area. I'm not sure if Aaron or Alex have any there. Okay.
Okay, thank you very much, Megan. I'm going to suggest that we move on to Gilbert Van Ness's presentation. Gilbert?
Thank you very much, Professor Lucas. I very much appreciate the invitation to come and speak today. When I received the invitation, I was talking with one of the other lawyers in her office and told that I'd been speaking with Professor Lucas, and he'd invited me to come speak to this conference on wildlife protection. And she says, he knows we don't administer the Wildlife Act? I said, yes, he knows that. He wants me to come and speak on our experience with administrative penalties. And she said, well, why? And I said, well, I think he thinks we're on the leading edge of administrative penalties. And she reminded me what happens to lemmings who are on the leading edge of a herd of lemmings. You tend to be the first ones to go over the cliff. So it's my one and only wildlife joke. Anyway, I'm not going to be speaking per se about wildlife legislation. In Alberta, if you look at the Wildlife Act, that legislation is quite what I would call traditional and has enforcement provisions to deal with offenses by taking someone to court under provincial offenses legislation. You go to court and you get a fine prescribed by the judge there. However, in other environmental legislation in Alberta, we have used administrative penalties quite extensively. And examples of the legislation is the Environmental Protection Enhancement Act and the Water Act, which is administered or dealt with by the Environmental Appeals Board, under the Public Lands Act, which is dealt with by the Public Lands Appeal Board. It also exists in Forestry Act and some other places as well. So we have some experience dealing with administrative penalties. So I'm going to talk a little bit about one example, the Environmental Protection Enhancement Act. The other legislations are fundamentally patterned the same way, so it would just be repetitive to talk about those other pieces of legislation. I'm going to talk to you about one of our recent cases, which is called Alberta Reclaim and Recycling, where the concept of economic benefit was dealt with really for the very first time. And then I'm going to talk to you a little bit about what's going on in the US EPA. They're probably the leaders in administrative penalties. And what's interesting there is they have computer models which are useful in dealing with administrative penalties. So first turning to the Alberta model, under the Environmental Protection Enhancement Act and the other legislation, they have a provision that's basically established that says a director, is a statutory decision maker under the legislation, can issue administrative penalties for the purposes of a prescribed contravention of the Act. And so if you go to the regulation, you'll see that all the different provisions that you can receive an administrative penalty are laid out there. And the administrative penalty can be for, as we were just discussing, for each individual day that the offense is occurring. And all of this was put into place first in the Environmental Protection Enhancement Act back in 1993. But in 2002, they added a second part to what you can assess an administrative penalty for, not only a day-to-day, each day of the contravention, but you can also add a one-time penalty to deal with the economic benefit that the person who committed the offense received. And so that's kind of the big new cutting edge, leading edge area of administrative penalties. The legislation then typically goes on to prescribe that if you pay an administrative penalty, you can't you can't be charged under the Act, under the other offense provisions with committing that offense. And then it prescribes, and I'll talk more about this importantly, that an administrative penalty can be filed with the court and can be enforced as for collection as if it's an order of the court. Okay, this is a very important change in the way that these administrative penalties have been dealt with in the past, and I'll talk more about that in a minute. You then have the regulation that always accompanies the empowering provision in the legislation. It prescribes typically what is required as far as the notice, what details need to go into the notice of the administrative penalty, and prescribes a limitation period, which is that it can only be issued basically 2 years from when it was discovered by the director. Then it goes on, the regulation typically goes on to put together the same type of matrix where you determine what the penalty is about. The matrices in Alberta tend to be simpler than that that Megan just described in the federal legislation. Basically, it's a grid that across the top has the type of contravention. Is it a major contravention, a moderate contravention, or a minor contravention? And then down the side is the potential for the adverse effect. Again, it's major, moderate, or minor. And then depending on this grid, you can go anywhere from a minor offense, which is kind of like a ticketable offense for $1,000, all the way up to a major offense, which is $5,000. Okay, so you look at that, you figure out where it falls in the grid. You then have a number of factors that can be considered. So once you assess the base amount of the penalty, anywhere between $1,000 and $5,000, you can go up or down. And while it's not prescribed, the traditional practice has been up or down by increments of $500. And the type of factors that are considered is the importance of the regulatory scheme, the degree of willfulness or negligence involved in the contravention, whether there's been any mitigation of the contravention, what steps have been taken to prevent further contraventions of a similar type, whether or not the person has a history of noncompliance. And the Alberta version of what a history of noncompliance is a lot less generous than the feds. We don't really care when it occurred. We don't have a limitation period on how far back we go. And it doesn't matter whether it's between different pieces of legislation. If you have a history of noncompliance in the Water Act and you are under the Environmental Protection Enhancement Act, that still is a non-compliance history that would be taken into account. The degree of economic benefit, and then any other factors the director considers important. So there's a great deal of discretion built into this model, much more so than I think what Megan was describing. And so that's basically the same scheme that occurs in Environmental Protection Enhancement Act, the Water Act, the Public Lands Act, the Forest Act, all kind of the same approach. The one big thing that's really missing from the regulation is this: how do you assess economic benefit? To try to take away this one-time economic benefit assessment. There's no guidance provided in the regulations at all, and as of yet, Alberta Environment hasn't really developed a policy, a very expensive policy to deal with it. So that area is kind of open, and we'll talk about the Alberta Reclaim case in a minute. Now, these administrative penalties have been around for a long time in legislation like the Forest Act and the Public Lands Act for a long time. They weren't as well developed in having the grid and things like that. They were more kind of like a civil version of ticketable offenses. The one big problem that existed until we kind of moved into this modern version of them is how do you go about collecting them? And some of them are $250, but under the Forestry Act, for example, we had administrative penalties that were hundreds of thousands of dollars because the penalty there is driven by what the price of lumber is. And under the old system, and in fact still for the Forestry Act, the only way to go and collect those administrative penalties is to go to court. You have to prove the penalty in front of the court, and then you can register it as a court order. Okay? In this new version of administrative penalties, and it hasn't come to the Forest Act yet, but under public lands and water and environmental protection, these penalties are now appealable to the Environmental Appeal Board. And because of that appeal mechanism that exists, you can now whether or not someone appeals it, you can take the administrative penalty and simply register it as a court order. You don't have to go through the process of proving it in front of a judge and getting them to issue a court order. You can just take the administrative penalty and register it, which means it becomes an enforceable debt. So all of a sudden, it becomes possible to more economically enforce smaller debts of like $1,000 or $2,000 or $2,500. You can register them as a debt, and you can, if nothing else, sell them off to a collection agency to try to get your money back. So that's one of the important factors of the modern version of the administrative penalty. You can actually collect those, because under the old regimes, hundreds and hundreds of thousands of dollars of penalty money was going uncollected because it was just too expensive to do that by having to go to court. So the Alberta Environmental Appeal Board has probably dealt with, maybe since 1993, about maybe 100 or so administrative penalties. My personal favorite that we get about once a year is someone who is quite convinced that despite the fact there's a creek through their land, that's their land. And Her Majesty's Creek, being Her Majesty's bed, bank, and shore, and Her Majesty's water, Her Majesty respectfully disagrees. And people go and muck around in the water course and obliterate water courses and things like this. And how do you go about taking enforcement action? Frequently, there will be an order having the person try to put it back. But sometimes that's simply not possible. It's not a viable option. So you are left with something like a warning letter or so, and that really doesn't do very much to someone who's quite convinced that this is their land. So they get an administrative penalty, and the board gets to hear yet again how this is their land and it's their creek. It's been in their family for hundreds of years, and the Environmental Protection, or Alberta Environment and Parks comes back and says, well, no, it's Her Majesty's land, Her Majesty's water, and typically the administrative penalty is upheld. So that's the classical type of scenario. And those type of penalties, really the idea is just to drive the point home that what you've done is a violation of the Act, and try to discourage people from doing it again, not only that particular individual, but to try to send a message in the community. That works really well in that type of scheme. When you're dealing with some sort of commercial operation, because the maximum penalty, like Megan described, for an individual is $5,000 in Alberta, doesn't matter whether you're a corporation or an individual, the maximum penalty per offense is $5,000. Even if you multiply that by 10 or 20, you can still end up in a situation where the administrative penalty is just the cost of doing business. And that's the case of Alberta Reclaim and Recycling. They were, and I'll tell you more about the details in a minute, but they were illegally importing beverage containers into the province, and they were returning them into the Alberta system. And the evidence in this case before the board was there were over 9 million of them. And the base penalty that they got, $5,000 per offense, added up to a whopping $75,000. They would have quite happily paid that and just carried on with their business, because it's just the cost of doing business when you're making millions of dollars. So that's where the new concept of economic benefit. In order to make administrative penalties useful for deterring that type of activity that generates a significant economic benefit, and where a $5,000 fine or even a $75,000 fine is just the cost of doing business, it doesn't do much. It's not really acting as a deterrent. So despite the fact that provisions were put in place in 2002, Alberta Reclaim is one of the first cases where Alberta Environment and Parks has actually used the economic benefit component. And so what was going on in Alberta Reclaim is they were getting beverage containers from the Yukon, and basically in the Yukon, the recyclers there are happy to give it away for free because of the cost of shipping it to some sort of place recycling. They were bringing it down to Alberta, and for a while they were operating their business legally, which was just repackaging the shipments that came in, and they would sell the recycled materials to places that bought recycled materials either in India or China or Ontario, wide range of places. However, they came across this idea that, well, they could make more money by returning them into the Alberta system. And that's the problem. That's the offense. Is you can bring beverage containers in to the province of Alberta, and you can then ship them, sort them, and ship them off for processing elsewhere. What you can't do is bring a beverage container into Alberta and return it into the system. That's because the system is what's called a closed loop. I go down to my local grocery store, and I buy a six-pack of Diet Coke. I'm quite addicted to Diet Coke, quite love the stuff. And I pay my, I think for a can is 5 cents. Okay. I go and drink my Diet Coke. Okay, the 5 cents goes from the grocery store, goes to the beverage container recycling management board. They hold it. I then take my 6 cans of Diet Coke back to the recycling depot, and I get my 30 cents back. Well, that money comes from the beverage container recycling management board. They pay the recycling depot the 30 cents to give to me, and they also get a handling fee. And where the handling fee comes from is not, unfortunately, not every beverage container that is bought in Alberta and the deposit is paid for gets recycled. Some of them get thrown away, so they have a bit of a surplus in money. But the idea is that this closed loop, the money comes from paying that deposit, okay? And the money that I get back when I return it to the recycling depot is the money that I paid. Okay? So no one's really out any money, it's just an incentive for me to go and recycle. When you bring in beverage containers from outside the province, from the Yukon, and you return it into the system, you're getting money from the system that was never paid in. And the consequences of that is if you do this enough, there'll be more money leaving the system than comes in, and the system will collapse. Okay? And Alberta actually has one of the best, the highest return rates in all of Canada for beverage containers. It's a very successful system. But if you allow this money to leave in large quantities, the system will eventually collapse. We'll have to find some other way to create this incentive. So that's where the environmental harm comes from. So the Alberta individuals running Alberta Reclaim stumbled across this idea. Why go to the expense of shipping it somewhere when we can just put it into the system and basically get your money for free? Right? And so they started doing that. They started returning these bottles in large quantities. And it became such a lucrative business that they bought the Ander recycling depot. Okay? Ander is where Premier Stelmach came from, a small little town. The pictures we have of the beverage, of the recycling facility is kind of a rundown old barn. The Ander recycling bottle depot runs 2 afternoons a week, I think Wednesday afternoon and Saturday afternoon. And after Alberta Reclaim and Recycling purchased it, it had a 1,000-fold increase in the number of beverage containers that were being recycled to the depot. Based on the very spotty records that we have, at least 9 million beverage containers were brought in from the Yukon and returned into the Alberta system. That's the records that we have. Okay, they're very few and they're very spotty. They're just the ones that they found. Okay, because the gentlemen with Alberta Reclaim and Recycling weren't very good record keepers. How this was stumbled across is someone was watching all this activity happen at a warehouse down in Calgary, or down in Edmonton, and phoned the Department of Immigration. Immigration went and stormed the place, and I think they eventually deported 12 illegal workers. And the people from immigration were looking at what these people were doing, and they took, when you return your recyclables, they turn them into bales. The bales get shipped off everywhere. Rather than putting bales together, which is what most recycling operations do, these workers were pulling the bales apart and sorting them into bags, and the bags had the word Ander Recycling Depot on the outside. What would happen is they'd get these bales from the Yukon, they'd tear them apart, put them in bags, truck the bags from the warehouse in Edmonton to the Andrew Bottle Depot where they'd be returned into the system. Okay? So immigration people call Alberta Environment. Alberta Environment shows up and sees what's going on, and of course is the exact opposite of what a beverage container depot has. And at the same time, the Beverage Container Management Board had started an audit of the Andrew Bottle Depot. And they were able to find records to the tune of about 9 million beverage containers that were imported in, I think, 14 different individual bills of lading. And so when you go 5,000 times the 14 plus other two charges, you get $75,000, which for these people is just the cost of doing business. So they turned around and issued a penalty for economic benefit. The total economic benefit based on the number of beverage containers that they found was $770,000. So when you combine that, the administrative penalty was $845,000. Right? It's then appealed to the Environmental Appeals Board, and the basis for the administrative penalty that the department chose was the gross revenue that the company earned based on the records that they found. And the appeal came in front of the board and says, well, you shouldn't be penalizing us for the gross revenue. You should only be penalizing us for our profit that we made. So we want you to deduct the cost of renting the warehouse, the cost of paying these illegal workers, on which the evidence, by the way, is they have no records for the illegal workers, but trust us, they pay them $10 an hour. Didn't go over well with the board. They had really spotty things to try to, in fact, they really, other than the trust us, the $10 per hour, they really didn't have very much evidence to show what their costs were. But that was the argument. Reduce the administrative penalty below what our costs are and just go after the profit. So that leads me to the core legal point here, is what is economic benefit? And the discussion that happened in front of the board, and this is the evidence of the director of Alberta Environment and Parks, is basically there's 4 types of economic benefits that you should look at when assessing this. The first one is where something was always illegal. There's no way to make it legal, like the importation of beverage containers returning into the system. That will never be legal. And there, the director argued, and the board accepted, that the economic benefit should be the total revenue generated. The next category was an activity that was unlawful at the time, but could have been legal. So, for example, if you are extracting gravel, you have your application into Alberta Environment and Parks, you just don't have your approval yet, and you jump the gun in a situation like that. Had you waited, the activity would have been legal, but you didn't. And so that's the type of scenario where the department argued that it would be just the profits that they would go after. There were 2 other categories that were discussed, unfortunately not in a whole lot of detail, and not really an idea of what type of economic benefit component would be applied. One would be where the offense occurred because the person who committed the offense didn't spend the money that was needed at the time that they should have. So, for example, for monitoring. They decided they weren't going to pay for the monitoring they were supposed to do. Okay? The problem is that the scenario there is you can't go and pay now, even though you didn't spend money. You can't go and fix the problem because the opportunity to monitor is gone. Okay? So you avoided an obligation by not spending the money at the time, and there's no way to undo that. Right? Now, there's not really there wasn't enough evidence or discussion about what should be the consequence of that, but that's the other category. The last one is where you didn't spend the money at the time, okay, that you should have, but you can spend the money now. So for example, let's say that you were supposed to be disposing of hazardous waste materials and you're supposed to be taking them to Swan Hills or to landfill, hazardous waste landfill, and paying the money at that point in time to dispose of it properly. And instead you've been stockpiling it, illegally being in violation of your approval. Well, that you can fix, because you can require the company to go now and deliver the waste to the hazardous waste landfill or to Swan Hills, and pay now what they would have paid back then. Anyway, the board for the particular circumstances upheld that this is not something that would ever be legal. So we accepted that the total revenue generated was the appropriate penalty. And at the end of the day, in fact, we fixed a math error of the department. You don't count beverage containers, you go by weight. And they made a mistake somewhere in converting, I think, kilograms to pounds or pounds to kilograms or something like that. So at the end of the day, the administrative penalty upheld by the board went from $845,000 to $870,000. Okay? And then we split it between the two operators of the company over time. This is the first decision of its kind. We have 6 others that are currently in the wings. One is a $2.4 million penalty under the Public Lands Act for illegally subletting a workspace. So you'll see more of these cases roll out of the board in the next year or so. The last topic I just wanted to talk to you about regarding, and it largely focuses on this economic benefit component, is under the Environment Protection Agency in the United States. They've done a lot of work on this, and so they've developed computer models. And one of the problems, and when you look at these other 2 categories where people didn't spend money that they should have, okay, what is the value of that money today? Every administrative penalty with economic benefit we've seen today hasn't worried about the fact that this money was collected over a 2-year period, and how do you convert that money to today's value, because the difference is not very great. However, if you see this, if this offense just becomes discovered, and for example, you have hazardous waste that's been building up and being stockpiled over 10 or 15 years, and you're now going to have to pay for it to be disposed, and you're looking at the administrative penalties. How do you convert that cost saving that the company had, the money that they were able to use for other things, not having to go and borrow that money from the bank to fund their operation? How do you translate the value of that? So one of the models that the US EPA has developed was what the Ben model. And the Ben model, you put all the information into a computer, and it churns out what the value of that money over time is today as to be the economic benefit. They also have a number of models that talk about the ability of individuals, of corporations and municipalities to pay administrative penalties. And where that comes from is a $870,000 penalty to these 2 individuals at Alberta Reclaim is fatal. Okay? They'll never pay that amount of money. $870,000 to a large oil sands facility, drop-in bucket. Okay? So in the EPA, they've also looked at how do you take an $870,000 penalty to an individual and convert that to the equivalent of something for a large oil sand company to give the same pain, or the same deterrence, I guess should be the better word. And the last model that they have is sometimes people want to go and do projects to do like creative sentencing instead of administrative penalties. They have a model that calculates what the real cost of that is to the defendant. So I think that those models as administrative penalties and this economic benefit get more entrenched, that those models will start to become more important here in Alberta. So there are my cutting edge stories. Thank you for sitting like a group of lemmings.
So I hope that you, the live audience, and you, the virtual audience, have been busy applying the information, the lessons that our speakers have provided this morning on administrative monetary penalties to the wildlife offenses that we all learned about, the federal and provincial wildlife offenses that we learned about yesterday. And I think you can see that if you start to do that, including the EPA models that you referred to, Gilbert, the results could be kind of interesting. So, further questions? Okay.
Thank you. Have a couple questions from our online viewers. One is to Gilbert. When an offender receives an AMP and decides to contest it, who represents the government? Do you have your own staff lawyers?
The board has 3 lawyers. One specializes in the public land side of things, one specializes in EP and water, and then there's me, who I do both. We don't represent parties. Our job is to ensure the board process is fair. We provide information to both sides, everyone equally. The director is represented by Alberta Justice, so they have a team of in-house lawyers, including a number of people who specialize in enforcement. And the person who's being accused or assessed the administrative penalty, their option is to hire outside legal counsel. Our process is designed to try to also make people able to represent themselves, which for administrative penalties is a bit easier than a lot of other issues that we deal with.
And this question is for Megan. There's kind of 3 questions in one. Do you see AMPs becoming the dominant form of obligatory compliance?
I think that we're hopeful that right now there is a gap in some areas where infractions they just don't warrant going for prosecution, and but there's not really an option in between that and a warning. So we may issue a warning or several warnings, and we're not seeing people come back into compliance. And so we are hoping that there are quite a few of those situations that AMPs will be used a lot in that context. But as for the predominant, I think it just goes back to the individual cases, and at that time, the enforcement officer will have to determine what they see as the best course of action. And so where you heard from Aaron and Alex yesterday, and Kevin, about the types of offenses that may be prosecuted, it's likely that those types of offenses will still warrant prosecution, and AMPs won't be replacing that. So that's probably the best answer I can give.
Okay. And I guess the kind of following from that, at what point does willful non-compliance force an actual prosecution, particularly if the AMP process becomes more routine and easier?
I guess again, it will go back to the type of situation for if it is one of the offenses that involves a mens rea component, then we won't be using AMPs, and whether or not that is prosecuted, it's at the I guess it's up to enforcement officers to first decide if they would recommend that, and then ultimately it's at the discretion of the public prosecutions to decide if it's worth going forward. So for those types of offenses, AMPs won't be a consideration at all.
Okay. And is there any provision for mandatory public notice of AMP penalties?
No, there isn't.
Just going back
ahead,
to one question, choosing between a prosecution versus administrative penalty, I think it's up to the officer, but also to look at the type of case that you have. For example, in Alberta Reclaim, my understanding is that Alberta Environment really thought long and hard between prosecution versus an administrative penalty. Part of their problem was the records from the company were so bad that trying to go to court and proving it in a provincial court on a on the beyond a reasonable doubt would have probably been an uphill battle, whereas one of the benefits of the administrative penalties is they're on the civil scale on the balance of probabilities. So you look at the strength of your case, it certainly warrants some sort of enforcement response, but what can you achieve with that enforcement?
Okay, a further question at the back.
Hi there, this question's for Gilbert.
Mm-hmm.
So you mentioned scaling up the economic losses for large companies, and often companies will have many departments or maybe even companies under the same corporate umbrella. So, and these companies are masters of their own supply chain. So if you're targeting a department that's upstream, let's say a chemical producer, and they're producing chemicals for the use of other divisions or companies in that same corporate umbrella, would you be targeting the economic gain of those downstream companies? And is there some problems for indeterminacy, or maybe the company can compartmentalize a little bit?
That, I think, certainly for Alberta and Canada, I don't think that's been sorted out, because I don't believe that that's really been a factor that's been considered yet, even on the criminal side of things, at least not very well. They certainly have discussed it. The model that is used by the EPA is based largely on tax returns, that you take the information on the tax returns. So it depends on how the company is structured and how they're filing their tax returns to do that. So that model right now doesn't take that type of thing into account.
I have a couple of questions as well things that haven't come up yet. I'm thinking about analogies between AMPs and strict liability offenses, to the extent that you can actually do that. But the first question is to both of you, is there any room for plausible constitutional challenges to AMP legislation? And I'm thinking particularly about charter challenges.
That's one of the things that we've been pondering when you start getting into administrative penalties that are $2 million or something like that. In that particular case, it's to a company. But what if it was an individual? Because the individual could have equally done something like that. And the way that Alberta Environment at least structures their process, I think provides some sort of protection to the constitutionality of it, because they do get a formal warning that they're being investigated for this. When statements are taken, they're getting the charter warning. And one of the big processes, really important processes in administrative penalties, is there is a disclosure package that goes to the person who's alleged to commit the offense with all of the information that's in front of the decision maker. And then what's called a due diligence meeting is held. So there's an opportunity for that person to make their case to the decision maker based with all the information the decision maker has before he makes his decision. And then you get an appeal to the board. So I think there's some protection, but I think the larger these penalties get, the greater the likelihood that you're going to get some sort of constitutional challenge.
I'm thinking about the idea of presumption of innocence. That leads us then to what Section 11 of the Charter actually says and what it applies to, right? Megan, any comment?
Right. I guess with our regime, we don't have a due diligence defense is not accepted, which is common with many regimes. It goes for our regime, we have purposely kept the penalty amounts very low so that they aren't punitive. Some AMP regimes, like the penalties, can be in the millions of dollars depending on the types of regimes and the regulatees. So ours are very low, not punitive. Those are the types of, I guess, just talking about the protections that when we were considering this issue. In addition, the notice of violation form, it is very detailed, and it too sets out all of the facts and the information that the violator would need to know about what they're being charged with. It's quite a detailed form as well, and I guess just with due diligence, we aren't punishing, and it's a strict liability offense in our or violation in our view. So it will, I guess, just with the whole purpose of the regime, it would, if to prove due diligence, and we feel it would be counter to the efficiency of this type of regime as well.
Okay. Further questions?
It's for Gilbert. I'm interested that this issue of revenue and possible costs on the monetary benefit has come up again. Mm-hmm. We had a session yesterday. I mentioned a case. The case name is Henneberry, out of the Nova Scotia Court of Appeal, where they had to address precisely that on a very, it sounds like a similarly worded provision in the Fisheries Act, the Section 79 penalties for monetary benefits. Mm-hmm. And on the appeal, they tried to claim that the trial judge erred in not allowing for the fact that gross revenue wasn't a fair assessment. So the same basic thing. I think they had a bit more evidence than which would have dealt with the problem anyway. Yeah. But in that one, the Court of Appeal pointed out that the term monetary benefit is different from profit and loss. Yeah. And they specifically said that it could be the case that at a particular point when the offense is committed, most of the expenses have already been committed. So it really is just gravy and an addition to the bottom line, therefore a benefit. So I've opened up the reasoning. And also said because of that wording, the penalty section as it's drafted gives a great deal of discretion to the trial judge to decide what constitutes a benefit, but that it shouldn't be considered to be traditional profit and loss. The way they phrased it was, it's not like filling out a profit and loss calculation for income tax. Mm-hmm. So.
And that was kind of incidentally discussed in the Alberta Reclaim case. And I think it also goes to Professor Lucas's question about the constitutionality that I'm personally, not the board, I'm personally more comfortable with going after the profits and comfortable that that's more likely to be constitutional than going after the gross revenue. Where the board went with accepting the arguments for the total gross revenues is actually based on some of the cases that I put up here, the talk about disgorgement and things like that from the Supreme Court. When the board, we were looking at those cases, they seemed to be at least open the way that total revenue was still a viable option. But it is something that in the constitutional side, I would be worried that it's the gross revenue starts to become more punitive than just going after the profits. And I also agree that what economic benefit means may not necessarily be prescribed by those traditional balance sheet terms.
Okay, further questions?
Hi, Magdalena Muir, Arctic Institute of North America at the university. Just a quick question, and it's really a follow-up on the question we've just had. When you start getting, like if you think of a strict penalty and what tends to be often a minor cost, but also based on not really going into the broader parameters, is there a lot of vulnerability going to open up for government if you start looking at what it might cost somebody to comply? A strict penalty might be a nominal sum, but then the ensuing compliance might be very costly. And so I'm just throwing these kind of thoughts out there, or if someone might choose to pay a penalty because it's an easy out, even though they may not necessarily be guilty because of the cost of defense. So would you get that into the whole issues if there's a wrongful imposition of a strict liability penalty, or just the overall costs of compliance, which might be wholly outweighed to even the revenue stream?
one of the factors, it's not a two-part answer. One of the factors that's taken into account is whether there's been an attempt to come into compliance. That's one of these mitigating factors that in the Alberta scheme typically sees it go up by 500 or down by 500, so that's not very helpful. I think that if you looked at the economic benefit argument, that you could probably take into account the cost of bringing into compliance. That goes probably to the type of offense should be more like, or the type of consideration should be more like profit versus total revenue. But our board is also mindful that we've had cases, not administrative penalty cases, but cases where the company is being ordered to go into compliance. And for example, we have a situation where a farm family is being told to fill in a ditch, and the ditch was built back in 1940 something. They acquired the land in 2011 and suddenly have this liability on their land of $350,000. And all they did was probably illegally clear the brush on the side of this ditch, and they're now being put to the expense of filling that in. So our board is certainly mindful of that type of thing, of the costs associated. More so under the Water Act, it seems to be where those costs are kind of really apparent than in other cases. And I think they probably would be mindful of that.
I would just say under our regime, where if we decide to go with an AMP, then we aren't considering the mitigation factors, but just in our enforcement and compliance policies, they would likely consider those kinds of issues before deciding to proceed with an AMP. And that's when they would still, it may not make sense to provide the penalty if it's not really going to be a foreseeable mechanism to bring them back into compliance.
Okay, it is time to wrap up the session. Please join me in thanking our speakers.